Welcome to the second hour. It's Justice Thursdays. Today is Thursday, the 13th of October, 2022. We're going to be talking about the Small Claims Court. We have a guest in the studio with us. But before we welcome her, let me tell you the day's proverb on behalf of C.T. Muga, who's away this week. The proverb is from Ivory Coast. Everybody loves a fool, but nobody wants him for a son. Everybody loves a fool, but nobody wants him for a son.
True.
It's relatable.
Yeah.
It's direct.
Make us laugh from far away, but not in my space.
Don't be mine.
Don't be mine.
The Honourable Stella Kanyiri is the acting registrar in the Small Claims Court. She joins us now for this Justice Thursday's conversation. Good morning.
Good morning, Eric.
Good to have you on the show. Welcome to Kenya's biggest conversation.
Thank you for having me.
Welcome to the hot seat of the biggest conversation. Make yourself comfortable. Yeah? So, you're the acting registrar.
Yes.
When we see people acting in the judiciary, we feel for them.
Why so?
Well, you know why, but let's not delve into those issues. I'm just being facetious and bringing issues. The Small Claims Court. We've talked about it here before, but there are people who may not have heard about it. In Kiswahili, I'm holding a pamphlet here. Mahakama ya Madai Madogo. So, Madai Madogo Small Claims. It's just so direct.
It's direct, isn't it?
It's so direct. What is a Small Claims Court?
A small claims court essentially is a specialized court. Specialized in the sense that it is established to determine or adjudicate over cases of low commercial value. The Kenyan case is that the Small Claims Court in Kenya, he has determined cases that are valued below Kenya shillings 1 million. So it is specialized in the sense that it only determines specific kind of cases. If you're to look at other magistrates' court, like the mainstream courts, they have a wide jurisdiction. The Small Claims Court has a narrow jurisdiction in the sense that you only listen to cases involving not a wide subject matter. The Kenyan case, we only listen to cases concerning to contracts, just contracts for sale of goods, contracts for supply of services. We also listen to personal injury claims and set off and counterclaim under any contract. So you see, our jurisdiction is very narrow.
So it's all civil.
It's all civil.
So it's we are not talking about cases where the likely fine is going to be less than 1 million.
The court is a civil court. So the claim, it's not a fine.
It's not a fine. It's not the cases where fine yake ni ngapi. The fine here ranges between 20,000 and 50,000 peleka small claims.
I think a fine presupposes that the matter is a criminal case.
Yes.
But in a civil case, you come and you state your claim. You're claiming, for example, I'm claiming from you something valued below Kenya shillings 1 million.
Okay.
Yes. So I want the court to either award me that or find that maybe you owe me any amount within that range.
But this doesn't mean that there are then other civil cases where the amount could be more than 1 million. That you will still have other cases where there's a claim on an amount more than 1 million shillings, but it will not be taken to the Small Claims Court.
Yes.
It will be taken to another court, but it still remains under the ambit of civil court.
Yes.
Oh, okay.
So any other case that is above, for contracts for sale and supply of goods and services, that is above 1 million, you can file it in the mainstream magistrates court.
Okay. Now, great issue here and confusion. We can clarify on the point of difference. Many of the contracts for supply of services would be employment contracts. Where somebody feels that, I'm in your employ and I feel you owe me service and it is within the range of less than 1 million, Bob. Does that qualify to go to the Small Claims Court?
No, it doesn't. If you look at the Act, there are certain cases that are excluded from the court.
Okay.
And cases emanating from contracts of employment are excluded from the court. So you cannot file a claim relating to a contract of employment in the Small Claims Court because there is a mainstream court and the labor court where the pecuniary value falls under the jurisdiction of the High Court.
Okay, so who's coming to small claims, for example? So what is the variety, or what are the range of cases then that we are seeing? Who would be coming to the court?
That's an interesting question, because what we realize is that before the establishment of the court, there was a segment of the citizenry that had been excluded from going to court because the court fee in the mainstream court was a bit high. and the procedures, they are complex. But now you see someone, like, for example, if Eric owes you 100,000 shillings, ideally, in the past, you wouldn't go to court. You would SMS him, call him, he'd block you. He doesn't pay. But now, you can file a case in the
CRB.
Yes, you can file a case at the small claims court. The filing fee is very minimal, at a maximum of 1,000 shillings. And the case will be determined within 60 days. So we are saying people who would ordinarily go to court, the small businesses, the ordinary mwananchi, are now coming to court to file their claims.
Okay. So, I mean, and I guess, so what's the nature? There's somebody owes for work that should be done according to the Act, work that should have been done, or rather work that was done that has not been paid for. You supplied them with goods or services, they did not then honor an invoice. What's the nature of some of them that we are looking at?
Some of the cases.
Yes.
Of course, we are saying even the people in the service industry. What do you call these people? The ones who are in the entertainment coming to court. We have the small businesses, where it's just you're supplying, for example, you're in supplies. You're supplying maybe general office supplies to a company, things like that. They're coming to court. And also the common mwananchi. But we also have the microfinance, the credit lending companies have flooded the court. Because I think very many people have been borrowing money there. And before then, they wouldn't take you to court if you'd taken a loan for like 20,000 shillings, because even the filing fee would not make sense for them to go to court to file a claim for 20,000 shillings. But now we are saying them coming to court and following these people who had taken up loans from the institutions.
The court is not very old. I mean, we're talking about
18 months.
Yeah, a year and a half.
Yes.
So how would you say? Well, previously this court did not exist for these cases or for these amounts under 1 million shillings. So what have you seen for the time that you've been there? What have you seen then in terms of? I think the word you used was flooding the courts. So then, how does that then say, or how does it fuel the narrative that there's an appetite for justice and there's an appetite for seeing some of these things then being sorted out?
For the period that we have been in operation, I think the data as at 10th October, we had registered over 18,000 cases. We had managed to finalize over 13,000 of those cases. And so the feeling that you get is that, save from the fact that there are people who had been excluded who are now coming to court, you realize that the issue of the court fees was a cause for people not going to court. Because where you know that you won't pay a lot of money, then you're able to come and file your claim.
Sure.
Yeah.
Okay.
So you're saying all these people now have come to the small claims court. How many cases have you handled in the last 18 months, or what kind of value of claims has the court dealt with?
So from the over 13,000 cases that have been determined, these cases are valued over 2.5 billion shillings.
Over how many thousand cases?
13,000.
13,000
Yes.
cases.
At present, we have 11 small claims court in one sub-registry. We have a court in Milimani. We have a court in Kajiado, in Thika. We have a court in Machakos, in Eldoret, in Naivasha, in Nakuru, Kakamega, Kisumu, and Mombasa, and a sub-registry in Makueni. So
are they within the judiciary? When you go to the courts, so you are directed to the small claims court? Or are they in a separate
all of them
space?
are in the existing infrastructure.
Existing courts?
Yes.
Okay.
Yeah.
So when you go there, what's the process? What's the procedure for filing? I mean, I'm assuming that this would be easier. Or like you said, previously people were finding barriers to filing some of these claims because of the filing fees and the procedures and all. So what is it that has been simplified that's made all these 13,000 plus people come to court?
Okay. So one of the major character of the small claims court is that the procedures in the court are very simplified. And if you look at our court, the small claims court in Kenya, is that for you to file a claim in the court, we have standard forms. Previously, you'd have to get a lawyer, because even the language which you need to write in those pleadings is a bit legalese. But in the small claims court, there's a standard form which you can fill in, so that even though you've not gone to school or you're not very conversant with matters law, you just fill in the particulars. And if you look at the Act, the small claims court is supposed to have someone called a clerk of the court, meaning that if someone, like, for example, is a vulnerable person, is not learned, you can come to court. And that clerk of the court will help you fill in the standard form, and then the same is filed. So the procedures are fairly simple.
Okay.
Even how we proceed, the language in the court. In the mainstream court, I think the formal language is English and Kiswahili. But in the small claims court, we are encouraged to even allow them to use any language that is appropriate, even Sheng, assuming there's a witness from Kayole. And they want to proceed in Sheng, and the magistrate is conversant, she can allow them to proceed in Sheng.
Just go ahead.
Yeah, just go ahead.
Let's communicate.
Yes.
All right, so filing is made easy.
Yes, filing is made easy.
Service?
So service is as in the normal manner, because for you to be able to respond to my claim, I have to serve you either physically, I can serve you electronically through email. But for us, because of the time limitations, because we only have 60 days to hear and conclude our matters, if I serve you on WhatsApp, Eric, and you blue tick me, that is proper service.
That's it.
If you don't have the blue ticks, I put it on my status, and you view it, that's proper service.
Really?
Right. Yeah, yes. Because you've been served, you've viewed, so you're aware. Because there are other people who will frustrate service, you will evade me.
Yes.
But if I have your phone number, I can serve you.
Yeah. From what you've seen, what is the most common way of serving people? Because, I mean, by the time somebody is coming to court for this, it's because they have tried to deal with this person directly. They've tried to send emissaries to them. They've even maybe tried to bring in the area chief, the area nyumba kumi mzee, and you're just not paying me what I'm due, right? And I've gone to court, and I've filed, and now I'm supposed to serve you. Of course, you're going to create all these barriers. What is the most common method being used to serve?
So luckily for the court, if you look at the cases that we're hearing, the commercial cases, so chances are you know each other.
Yeah.
Like, for example, if I supplied you goods, I know where your company is situated, or I have your phone number. So we're saying the common way of service is through email and through WhatsApp. Right? The in-person service is not so common, but through email and through WhatsApp.
And even for the mobile lenders, it's the same.
For the mobile lenders, no, those ones
because
they
the
do.
mobile lenders have never met me. They have only lent
They have
me
your
money.
phone number,
right?
So what they'll do, because sometimes the court will insist, how sure am I that phone number belongs to you?
This person.
So the court will say, send that person some money. Then they'll send you 1 shilling. Then they'll get the M-Pesa message saying, Eric, Latif.
Right.
So that's proper service. That is your phone number. Yeah.
Okay. So it seems that it is, I'm trying to use the word carefully, that it is simplifying the process so that there can be, a quick justice here, quick access to justice.
Yes.
Now, as we're having this conversation, we've come off a day whereby clearly the threshold for evidence is seeming like doesn't really matter.
It's a pendulum.
Yeah, I mean, it swings whichever way you would like it, and whichever way the wind is blowing one day, then we'll go with it. Now, what then is used as a threshold for evidence in this case? If I'm coming and I'm saying that Eric and I had a transaction, I'm coming to the small claims court and I have it on an SMS that he said on an SMS I owe him some money. Is that enough for me to come and present it to court and say, look, this is what we are agreed. Here are the messages I have been showing him. He's been sending me messages over the last 1 year. I've not, responded. What's the threshold for evidence here? Hearsay is obviously an issue here and there, but is it simplified to the point whereby previously pieces of evidence that you would not use in a court of law then can be used in the small claims court if we're using WhatsApp and blue tick messages as service?
So the evidential threshold at the small claims court is slightly lower. This is because the Act is very explicit. It states that the court is not bound by the strict rules of evidence.
Okay.
So that is to say, evidence that would be inadmissible in another court can be admissible in our court as long as the court finds it to be believable. Right? For example, if you have a text message, you can print out and give to the court.
Yes.
In the other court, they will require that you even produce a certificate to show that your phone was in a proper working condition. There are things that you have to back up your claim.
Right.
But if this is printed from your phone and the other party is not disputing, so the court will admit it as evidence. Yes.
In many cases, like you said, Stella, people will come to court. Some of them, don't have any written proof of a contract. So it's a verbal contract in very many cases. You are supposed to supply me eggs at my shop, and I was supposed to pay you. You brought the eggs. I told you, wacha niuze, kujia pesa kesho. Kesho you come, I give you an empty tray. I don't give you your money. You can clearly, you brought the eggs. But there's nothing to prove that there was such a conversation or such an agreement. Now, when you come to court, in many cases that you see, how do people prove that there was actually an agreement and the value of this agreement?
So for those contracts involving the very small businesses, right, they may not have those written agreements. But for some reason, you'll find there was an SMS I sent you asking, ile pesa yangu utanilipa siku gani? There is that one of communication.
Right.
So I'll say that I gave him my 30 trays of eggs for him to sell. There was no written agreement, and he has not paid me. I've tried following up on my payment. He's refused to pay, right? So the court can find those messages, if they are, to be supporting to my claim, right? And where maybe the respondent comes in and maybe denies, then the court will have to weigh and find whether I've approved anything. And if the court finds that maybe I've not proved anything, then they will dismiss my claim. Yeah.
And how do you determine the value? So someone comes and says, I supplied 30 eggs, 30 trays of eggs. Just an SMS saying, ile pesa yangu, does not show the number of trays of eggs, does not show how much a tray was going for.
Or that we're even referring to this transaction of the eggs.
Yes.
It could have been something else.
I'm just seeing the difficulty here that
there'll be that difficulty
the judicial officer has.
Then the elements of that contract will not have been proved, because you're saying there was a contract, but then there's no agreement. So unless where there are other factors around that for me to see that there was some sort of agreement, then it will be very hard for the court to agree with you that you indeed supplied a person X with those 30 trays of eggs. Yeah.
Okay. Are you finding, and this is interesting because, again, talking about access to justice and making, access to justice a lot simpler with this, campaign that could become a way of doing things judicially in the country, which the Chief Justice was very serious about. Now, the Small Claims Court being one of the drivers of this access to justice. Do you find that those who make claims, looking at this short period through which a case must then be concluded, the 60 days, do you find that those who make the claims are in the majority when it comes to the rulings being made in their favor?
The ones who
are making the claims, who are, bringing the claims to court?
I think if you look at the value, the 2.5 billion in less than 2 years, then that would state that the majority of the claims could have succeeded. Okay. Right? Because then I will not be able to know per every adjudicator how many claims are getting allowed or how many claims are getting dismissed. But if you look at that value, given that the pecuniary jurisdiction for the court is 1 million, so for you to reach 2.5 billion, that means very many claims are being allowed.
So what's the statute of limitations here? Because the Small Claims Court was established 1.5 years ago, can I come to you and say, well, okay, thank you very much for this court that has been established. This fella owes me money 10 years ago. Can I come and then make use of the court for a case that is 10 years old, as an example? So
that depends. So we're hearing two cases of civil nature, contracts, and the ones for civil liability. So, of course, for contracts, they have the time limitation for 6 years. For the civil claims, it's 3 years. But for the civil claims, assuming the time has lapsed, it's already, let's say, 3 years and 5 months. So you can come to court and ask court to give you leave to file your suit out of time and explain why you are not able to file your case within the time period where you're supposed to have filed the case. Because you can say, I was not able to trace the respondent, but now I know where he lives. Now allow me to file my case so that I can prosecute my matter.
Okay.
Yeah.
Can one argue that the court didn't exist? Can
I say that there was
I didn't
all
have
these elements of the higher court, as it were, I was not able to take. But now that through this new access to justice, it has come about. This court did not exist. Now that it exists, and I have been battling with this issue for the last so many years, will the court hear me?
Yeah, you would. Assuming you come and state, I was not able to pay the accruing filing fees in the other court, but now I'm able to pay the 200 shillings. The court would allow that application. Because if you look at the small claims court, core at the small claims court is enhancing access to an expeditious delivery of justice.
Okay.
So in any way that we're able to expand those avenues where people are able to access justice, then you're supposed to do that.
And in terms of a footprint of accessibility around the country, you talked about 11 courts. Where are the rest of the courts, apart from the Milimani and the other one? Where are the rest of the courts? And are we looking at a situation where people must then leave their area of residences around the country to come to Nairobi, or how does this actually work?
So currently we are in 12 out of 47 counties. If you look at the provisions of Section 4 of the Act, ideally we're supposed to be in every sub-county, at least in every sub-county. So we're hoping to expand our footprint. If you're able to get additional adjudicators this financial year, we should be able to move into 24 other courts and increase our footprint in other counties. But presently, I think in 1 year, we've tried to cover sort of a third of the counties in the Republic. Yeah. So I think that was good progress.
Who's the officer in charge of the small claims court, of a court? Is it a magistrate?
The person presiding over a small claims court is called an adjudicator.
It's an adjudicator?
Yes, but currently we have magistrates who've been designated to serve as adjudicators, because we still don't have adjudicators hired specifically to sit in the small claims court.
So what would that look like if we had the adjudicators specifically hired for this? Would they be at the level of magistrates?
Yes, if the qualifications for adjudicators as laid down in the Act are similar to those of a magistrate at entry level. Only that the Act presupposes that they can be hired on contractual or on permanent terms. So those are issues that the JEC will have to consider before they decide how they want to engage the adjudicators for the small claims court.
Okay. Let's take a break. It's 29 minutes after 7. This is the Situation Room, live on SpiceFM and KTN Home and online. Our guest this morning, being Justice Thursday, is the Honourable Stella Kanyiri. She's the Acting Registrar of the Small Claims Court. We're looking at what the Small Claims Court has been doing in enhancing access to justice across the country. Cases where people are talking about money owed to the tune of up to 1 million shillings, whether it's a contract for services, contract for delivery of goods, and such kind of other disputes are the ones that are taken to the small claims court of a civil nature, not criminal. And we have got to be very clear. So those are the ones that are taken to court. Let's take a break here at this point.
This is the Situation Room, the only way to start your day.
The Honourable Stella Kanyiri is the Acting Registrar of the Small Claims Court. We're talking about this court and what it has done in the last 18 months. Very many cases taken before it, 13,000 determined, value worth 2 billion shillings unlocked?
2.5 billion shillings.
2.5.
16 months actually, not 18, 16 months.
16 months. Yeah. 2.5 billion shillings worth of money unlocked from the system. Just people being able to pay. Are there cases where people who feel like, they haven't been served properly, where they feel, okay, I don't agree with the determination of the adjudicator in the small claims court, and I want to not pay this person? What do they do? Where do you go? Where do you escalate this matter?
Where there's a judgment that is against you and you feel like you don't want to pay,
yes,
then you have the right to appeal to the High Court.
So you go to the High Court straight?
Yes.
Not a magistrate's court?
So all matters emanating from the small claims court, assuming you want to appeal, you appeal to the High Court on matters of law only, and that appeal to the High Court is final, meaning you can't go to the Court of Appeal.
What do you mean on matters of law only?
You can't go to appeal on matters of fact. You can say maybe the adjudicator misapprehended this part of the law, but you can't go and say that.
Okay, explain it in very, very simple terms. So I've been taken to court by Ndu, okay? Because she supplied me, same example, X number of trays of eggs. I sold the eggs. I paid half. She claims I didn't pay the other half. Now I've come to your court and the court has said you ought to pay her for the other half. And I've been saying there was no other half. I paid everything. Now, I feel that I haven't gotten justice in this small claims court. I'm going to the High Court. Now explain. Matters of law, not matters of fact.
So you say the way you'll determine a matter will be based on the specific sections of the law. Then it'll also be guided by case law.
Okay.
Right? The cases that have been determined by superior courts are also binding on you. So assuming I applied a case, then maybe there's been another decision that has overturned that one. So I have misapprehended the law. right?
Right.
And for example, assuming there was a judgment that was against me in the small claims court, and I feel like the procedure, for example, I'm supposed to be served and given 15 days to respond. I was not. There is a section of the law in line with the Act that was not complied with. So the court can find that there was that misapprehension and ask that the matter be heard afresh.
So that whole complication that we're trying to remove by introducing the small claims court is reintroduced if you want to appeal the decision of a small claims court. Because the whole thing was that whole understanding, X section, this of the law, case law, filing this, going to a lawyer. That's why I was coming to she was coming to the small claims court. And that's why I also agreed to come to the small claims court. Now you tell me, if I feel aggrieved,
yes,
I should now start applying those other stories.
Yes, but if you look at many other jurisdictions like Uganda and South Africa, all decisions, there is no right of appeal from decisions from the small claims court. I think because the assumption is that these disputes were not complex, they involved a little amount of money, so ideally, and all parties would be agreeable to that decision. But for the Kenyan case, there was that element of being given that
you can appeal
that decision,
but be prepared to do the work.
Yes, because now you have to follow the normal way in which cases are filed in the High Court. You won't get any preferential treatment because you're filing a case from the small claims court.
Okay.
Yeah.
Okay. Do you foresee a time, because it seems, you're talking about the flood of cases, 18,000, so you're looking, if you want to do that average, you're looking about 1,000 cases a month coming in over the last one. And do you foresee a situation whereby it's going to start to taper off? Because it seems as though there were a lot who were just waiting for this reprieve. Or are we going to see, if you're able to, if you would make a prediction, that are you seeing now the cases reducing, or are people now switched on in terms of knowing that, all right, if this dispute, even if it takes a month, I'm going to then be able to go to court? Or have you now, dispensed with the huge number of cases that were there and then seeing
the numbers reduce?
Yes.
I foresee the cases being filed increasing. Remember when we started, there wasn't enough stakeholder knowledge about the court. So we had to do a lot of sensitization and stakeholder training. And we saw the uptake of the court go up. And if you look at the courts that are the courts situated in the peri-urban areas, not in the very urban towns, the value of the cases that are filed even in the mainstream courts would fall within the below 1 million, right? So there's a lot of work for the small claims court, even for the courts outside Nairobi. But of course, in courts like in the urban towns like Nairobi, Mombasa, Nakuru, if the jurisdiction was enhanced to around 3 million, then the numbers would still be higher. Even with the jurisdiction for 1 million shillings, we still have a lot of cases that are being filed and will continue to be filed in the court.
Are there some court stations that are getting more applications than others? And bearing in mind that the law says that this matter must be heard and determined within 6 months' time. So are there some adjudicators who are more burdened than others? And what do you do in those cases?
Yes, there are. You look at the cases that we're handling, the contracts. So, of course, ideally, that kind of business would be happening in the urban towns. So the court in Milimani, in Mombasa, in Nakuru, Eldoret, and Machakos, you can tell that cases, the numbers of cases being filed is very high. So, of course, they're getting overwhelmed because, like in Milimani, in a month, we register around 1,200 cases in a month.
Wow.
We have around 10 adjudicators. So, of course, there are cases that majorly will be had within the 60-day timeline, and the others, because of other reasons, might extend beyond the 60-day timeline.
Okay.
But what I know is that we have been able to manage an average time of 37 days of conclusion.
Okay.
So despite some of the cases going beyond the 60-day timeline, we've been able to maintain the average of 37 days.
Okay. Since this court was established, excuse me, then to be able to handle, so are we looking at 200 shillings for filing fees kind of thing? Does it go beyond that? That's the first question. And then, do I need a lawyer to go to small claims court? Because if the point was to say, okay, reduce the amount that you're going to spend on filing fees, can I represent myself? As in, has the process been made so simple that I can then bring my evidence that I need, and I don't need a lawyer with the, legalese then to represent me?
So the filing fee is capped at a maximum of 1,000, and it's banded, meaning from 0 to 200,000 shillings, you pay 200 bob. 200 to 400,000, you pay 400,000. You pay 400 shillings. 400 to 600,000, you'll pay 800 bob, and up to a maximum of a million, where you'll pay 1,000 shillings. That's the maximum that you pay on filing fee only. All other services in the court are zero rated. So assuming you want to get a copy of an order, copy of a judgment, proceedings, a decree, a warrant, all those things, there's no filing fee that accrues from those services from the court. On the issue of representation, this is where it gets very interesting. Because if you look at Section 20 of the Act, it presupposes that there are 3 ways in which you can represent yourself in the small claims court. So one, you can represent yourself. Where you come, you file your claim, and you conduct you prosecute your case in person. So secondly, you can also get an advocate to represent you, as is the normal way. And we've seen that in very many cases, more so in Nairobi, the parties are represented. And then thirdly, we have what we call an authorized representative, which is to say that assuming I'm not in a position to go to court, let's say, for example, I'm facing some kind of inhibition, I'm not learned, I'm old, I'm sick, I can get someone who I am supposed to give them leave to act on my behalf. Then that person will go to court, make an application and tell the court, I want to represent Stella. And the reason why she cannot come to court is because of reason X, Y, Z.
Right.
Then if the court agrees, then they will allow me to represent Stella as an authorized representative. So, and this you can only do this in the small claims court. In other courts, you cannot represent someone if you're not an advocate. You either represent yourself or you get
Your
an advocate.
client. Yes. What do lawyers think about the small claims court? This is a question that's been asked by Andrew. He says, look, we see very many lawyers who are ambulance chasers, and some of these cases involve figures that are less than $1 million bob. Now, they are being removed from the equation. Has there been any negative vibe from lawyers?
I think initially when we started, they were not very sure how the court was going to work for them. But I think more so for the young lawyers, it's working for them, because we had an argument with them. We had a stakeholder engagement in Kanyiri. And so they were being asked, if you had a big brief, for example, let's say, for example, Kenya Power.
Right.
And they pay you 500,000 shillings. And that case takes 5-6 years in court, right? And you get a small case where, for example, for around $1 million, and it takes 30 days. And this client pays you 60,000. So in 2 months, you're earning 15,000 shillings per month. In the other matter, if you have to divide how much you're making per month, you're actually earning less. The brief is big. It's occupying your office. You've got all these
And
big
it
files.
takes a lot of work.
A lot of work. But if you look at it, you're earning less money. So I think they've also seen that time is also a factor, or in when you're an advocate, as a cost.
Right.
So if a case is taking you 5 years, is it really worth your time? Or can I prosecute this matter in 30 days? And it is adding value to my practice.
Okay.
So I think for the young lawyers, they've gotten it, and they've actually they've embraced the court, more so in Nairobi, in the other urban towns.
So you're seeing more and more of these lawyers actually advising the clients to go to the small claims court, where a matter will be heard and determined very fast.
Yes.
It's a good thing.
It's a good thing.
Absolutely. I'm looking at...
Looking at time as a cost of practice. I think that they can now connect the dots and see is this time that I'm expending on this matter, am I getting adequately compensated for the time that I'm expending on this file?
Is there any collaboration then with the small claims court and the alternative
Justice
system, whereby in a community setting, the people who may have information about a particular case is not necessarily structured, right? In that sense, is there or would there be a possibility for collaboration between the two systems, especially now that you're looking at in the next 1 year or so going into other areas, in other counties, whereby in some cases you might have information that's not necessarily down on paper, but other people are privy to the information and that may be used in a small claims court?
That's interesting, but this is what I say. If you look at Section 18 of the Act, the court is mandated to adopt other forms of ADR so long as the consent of parties have been sought. For example, if parties appear before the court and say, we wish to be referred to mediation, the adjudicator, if the parties are agreeable, will refer that matter to mediation.
Right.
Where, for example, they appear and state and tell the court that, for example, in our contract, there's a clause that is very specific that any dispute has to be referred to arbitration. Then the adjudicator will refer that matter to arbitration and close the file. So, where maybe they want to go to the AJS, for example, they want to be heard by Wazes. I don't think the adjudicator would decline, because at the end of it, you're trying to achieve the ends of justice. Yeah. So you will refer them. In case they don't agree, they can always come back to court. Yeah.
Are there cases where maybe the adjudicator looks and sees the fact as they are being produced in this court, maybe they are best if they are handled by the Wazes? Just like those ones we were saying, okay, the dispute here is the number of trays of eggs. There's an agreement that yes, you supplied the eggs. There's an agreement that I paid you. But the dispute is, did I pay for all the 30 trays or did I pay for 19? And where you can say, this probably, if you had a local mechanism where you sit down and thrash these things out, people who know the two of you would know who's lying better than I, who's just an adjudicator. Are there cases where the adjudicator then advises parties to go to AJS?
I presuppose they would, but what I know is that they would tell them, for example, there was a case that had been filed for around 3,000 shillings. So I know the adjudicator told them, I'm not going to sit here and listen to a case for 3,000 shillings because it's fairly simple. I'm giving you time to go and talk and agree, because you're in a position to agree.
3,000 shillings?
Yes.
Wow.
Go and agree, and which they did. Because you see, you're going to expend time listening to this matter, take 60 days, and they could have easily taken a sidebar, discussed and said, okay, I'll pay you, I don't have money, but I'm willing to give you 1,000 shillings every month, then I'm done with the debt, which is what was done. So even as they sit and adjudicate over this matter, they also sort of mediate, they're also able to mediate in those simple disputes and allow people to discuss and come back and consent, right? And that consent is not recorded in court as an order of the court.
You actually bring a very interesting angle here, because we even talked about it many times, where in many cases, people are going to court, to the police, not because they really want to pursue a matter, but because they want to feel that they've been heard. They just want the other person to acknowledge that I have a case, acknowledge that I have a grievance. And so they'll say to the patana mbele, they'll either go to the chief to report, they go to the police, eka kwa OB, niko na OB nilikureport, I just want you to be called by the cops, so that you acknowledge that there's something I'm raising. Do you see many of those now coming into this small claims court as well? Whereas, like now in the case of 3,000 bob, it's takupeleka kotini, my friend. I just wanted to acknowledge that you owe me. Simple.
It's actually what was happening prior. For example, if someone owes you like a debt for 500,000 shillings, and so you'd see people, you go report to the police station, and it is framed as a charge for obtaining by false pretenses. So the person is charged. So you want them to get charged and threatened a bit so that they're able to pay. But the others who don't care, they still won't pay, right? So you might not get a judgment in your favor, and you still won't get you 500,000. So Kenyans have realized, okay, there's a chance if I take you to a criminal court, I might not recover my money. But if I come to this other court, I'll be had in an expedited manner, and I will recover my money. So now they're coming to this other avenue because they are sure that they will get their money back. When they used to go to the cops, they're trying to threaten this person into paying their money, because no one wants to be arrested on a Friday and sleep in the cell till Monday. So if you're arrested on Friday, then you quickly pay up. But others won't pay. They go through the whole motion of the court process. If they are lucky because of this, the evidential burden, they are found, they are acquitted, and you still lose your 500,000.
That's interesting. So what's the spirit of the court then? And I ask that because, is it to say that, look, if there are folks, we're looking at justice, if there are folks out there who are owed money, who are owed something genuinely, is the spirit of the court to make sure that people get what is due to them? Or is it to then make sure that justice at whatever level is applied equally and evenly? Or is it to say, look, I have a genuine case, I've come before court? Is the spirit of the court to make sure that this aggrieved party then is sorted out, or to still listen to both sides and then make a judgment equally? And I ask that against the backdrop of courts like the Supreme Court, who will make a ruling on a national level, taking so many things into consideration.
Including public interest.
Public interest. Are we looking at what's going to happen if we rule in this manner? Taking all of that into. So is the spirit of this court to make sure then that aggrieved persons are heard and their issues are sorted out, or are we just looking at balance?
I think there's been a misconception that the Small Claims Court is sort of a kangaroo court, where the rules of natural justice do not apply. They apply. Only that they apply in the context that the procedures are informal, they're simplified, and the court process is expedited, right? Informal in the sense that what I earlier said, where what might be inapplicable in another court might apply in our court, because we are trying to achieve the ends of justice. And if you look at the objectives of the court, the main objective of the court is, as I said, is to enhance access to an expeditious delivery of justice. The other objective is to reduce the cost and time of determination of commercial disputes, and the third one being the overall reduction of the backlog in the mainstream court. But the one for ensuring access to justice is number one, is the main. The other two are attendant to the primary objective of the court. Yeah.
Could you throw and this is the thing, because it's such a delicate balance sometimes, Honourable, when you bring something before an adjudicator who is going to look at the facts, who is going to look at the issues. So then, is it also then dependent on procedure and process? If a signature was missed out, or if you're not able to look, in a situation where today, for example, and because if we're talking about making a simpler issue, sometimes you send, as an example, you send money to somebody and they say, don't send it on this number, send it on another number, right? And I come to Small Claims Court tomorrow, as an example. We both know that you were the recipient of this money, even though you asked me to send it on another number. But if I come to court, court wants to know who this number belongs to. It could not necessarily belong to me, it belongs to somebody else. So looking at procedural issues then, is the court going to rule based on the hard facts? Not necessarily the truth, but the facts.
In arriving at a decision, the court, of course, has to look first at the facts of the case, and then apply those facts to the law, in line with the Small Claims Court Act, any other applicable law. And as you may be aware, the adjudicator is empowered by the Act to create their own rules of procedure. They're not bound by the civil procedure rules. The court can create its own rules.
Yes.
Right. So if the court finds that signature, so for example, the number that you sent was also Eric's number, the court will rule in your favor. Yeah, because I'm sure there will be other things that are supporting. These transactions are not just one-off. The other things that are, it's a chain. I called you, I texted you. So you have all these things to support whatever you're claiming. It may not be something direct, but there'll be other things that are supporting whatever you're claiming. Of course, if you've got nothing to support, then it will be very hard, because assuming we get a report from Safaricom from Airtel saying that number is registered in another person's name.
Exactly.
So that would be hard for the court to make a ruling in your favor, because that number does not belong to the respondent. But where it could still belong to someone else, but where there are other, for example, there was a message that we see, Tuma kwa hii number. You told me to send to that number. So there is that communication. So the court will find that maybe there's a reason why you did not ask me to send money to your number, and you asked me to send to this other number. So the court will weigh the facts and the merits of the case. Yeah.
In cases where at the point of service, taken to court, I've been told to serve, I have served, and the respondent has actually come to court the first time, but they don't come again. What does the adjudicator do?
Well, that's very simple, because assuming I serve you, you come to court, so showing that you are now aware of the case.
Right.
You don't enter appearance, you don't file your response.
Right.
The court will proceed to enter judgment against you, because you are aware of the court, you are aware of the case. But where, for example, I file a statement of claim today, we normally give you a mention date within 14 days. So you come to court and say, I have served. The respondent is not present. The court may ask you to serve again. How or which manner did you serve? You'll say through email. They'll ask you, try serve through another mode, maybe through WhatsApp or in person. So you'll serve again. Then you'll come and file your certificate, your return of service, certifying that I served this person in this manner. So if the court is satisfied that you are adequately served and you have adequate information as to the case, they will proceed to enter judgment.
Okay.
But where you appeared and you never came back again, you had knowledge of the case, You decided not to defend your matter, so the
Right.
court will proceed to make a judgment.
What if I turn up on the 7th month and they say, Your Honor,
I'm here.
I'm
Didn't
here.
know.
Look at my leg. I was involved in a motorbike accident. I've been in hospital. My leg was like this.
So that's a bit complex because you showed up. It would be different where, for example, you had filed a case against me, and you're telling the court that I never enter appearance. I don't come to court, but you're telling the court that you served me, and the court finds that you served me
Yeah.
and enters judgment.
Yeah.
Then I come to court and tell the court, I'm applying to set aside this judgment because I was not served, right? So where the court finds that I was not served, they might set aside that judgment and and have the matter start afresh. So where I'm allowed to put in a response, and the matter is now had again, and a new judgment will be issued.
I guess what I'm asking in a roundabout way is, can a respondent file for, what's it called? An adjournment.
Request
of
for
a
an
case?
adjournment.
Yes.
For 7 months?
For whatever reason, yes.
Yes, you can.
Because, you've just served me, but here I am. I have just gotten this deal to go to Saudi Arabia.
Well, so now...
Kazi ndio hii, si unataka pesa? Ndio hii kazi. Wacha nikafanya kazi tukuje to deal.
So you can get an adjournment, but not an adjournment for 7 months.
Okay.
If you look at the Act, the adjournments are actually capped to 3. And these ones can only be given in exceptional and unforeseeable circumstances. Because remember, you only have 60 days. So if I give you an adjournment for you to go to Saudi and come back next year, February,
What are we doing?
so the case will be in the system and it will be reflecting as a case backlog. Because for us, any case that is above day 60 is a backlog.
Backlog.
Yeah. So they won't allow. You either defend your case or you pay.
Okay.
Yeah.
Honorable Stella Kanyiri, thank you very much for joining us. Honorable Kanyiri is the acting registrar at the Small Claims Court. We've been talking about the Small Claims Court and how they are enhancing access to justice.